Hello again. In the break, I had 4 questions, very good questions, so I tried to answer them. The first question was the question of freedom to operate. I'll just try to explain what is freedom to operate. We just talked the first lesson about patentability. To be patent is to be novel, having inventive step, and to be with a useful technology. This is okay with you? Now, what is freedom to operate? One of the questions was, if I have a patent of a technology, should I have freedom to operate to do what I'm sure to do? I shall give you an example. If you'll see all the cars in the road, all the cars, think about the diesel cars, the benzene cars, the electric cars. What they have all in common?
They're all cars.
They all have wipers. You know wipers? All have wipers. So let's say that a guy has a patent about a wiper system. Let's say a wiper that stops and reciprocally working at predefined procedure. 1 a second, 2 times a second, etc. So you cannot produce a car, you cannot sell a car without a wiper. Okay? So let's think about General Motors. General Motors have hundreds and thousands of patents about the mechanisms, the electricity, the engine, etc. They cannot really sell their car without a system of whipping the windows. So you have no freedom to operate in the industry of cars if you have no access to the wiper patent. So if you have a patent, this is not really says that you have a freedom to operate to do something. Let's say I'm Pfizer and I've got the patent for Viagra. Very nice molecule. Doing something like $2.5 billion a year. Very nice molecule. Now, can Pfizer sell Viagra just because they have the patent? No, not at all. If they have patent on Viagra, they say they can exclude other from selling Viagra. Eli Lilly cannot sell Viagra, but it's not saying that Pfizer themselves can sell Viagra. They should have regulation for that, a PMA type regulation. So having a patent is saying nothing about freedom to operate. Now, what we have now today, we have bundles of very strong companies, each of them have a strong bundle of patents. Now, none of the companies has freedom to operate to do what they are wishing to do. They can use by permission other patents, and they cannot do it without permission. What we have now is a condition that all the canons are aimed to each other, and all the companies are so-called infringing others' patents. Now, nobody will sue them, because if you tell everybody I infringe your patent, I go to court and find you infringing my patent. So very strong companies which have a lot of patents infringing all other patents or can use all other technologies, whereas small penetrators like startups cannot do nothing because they have no enough power to threat others. There is no equilibrium of threat between the small and the big, only between the big and the big. Okay? So I'll try to give now example about the shade. Just before the light was collapsed, I thought about the window shades. You know that there is a light outside, and when I begin to talk, it was too light, and now it's very nice, it's ambient light now in the room. So let's talk about window shades. Let's talk about 3 generations of window shades. The first generation is a physical window shade. You know windows, you can move them on the X, you can move them on the X, you can have the theta inclination on the flaps. You follow me? There are hundreds, thousands, millions of patents about physical shades. This is the first generation. Now, second generation of shades are electric shades. Here, electric shades. I just press it to see the time roll. This is, it's not working now. Okay, okay, you see, I moved the mechanical flaps by electrical mechanism. So first generation is mechanical arrangements, second generation in devices is mechanical arrangements. This is okay? Now please tell me, what is the third and last generation of shades? Window shades. What is the last generation? Think very practically. First generation, just having the cord opening and closing.
Automatic. You use
It's not automatic. This is a kind of automatic. I just push the button. This is not automatic. The word is not automatic. What is the word?
sensor.
We have sensor there. So if we have a sensor and we have automatic, what is the word?
Computer.
Not computer. It's not computer. It's another word. Somebody? Too much for me, perhaps. I'm talking about the feedback mechanism. This is the word I wish to have. Now, if you go to my house, you'll see that I have a sensor here, which you can call it I feel. It will know what you like. You know how much temperature you want in the room. It will know what is relative humidity you like in the room. It will know what is the epsilon, what is the flux of photons you like in your room. I like this epsilon flux because it's nice to a lecture. So you calibrate or you teach him what you like, and he will tell the mechanical arrangement in an electrical way what to do. So this is a feedback mechanism. So the first one is mechanical, the second one is electronic one, the third one is feedback mechanism. So the question was just in the break, if I want to have to conquer the world and to win the world of window shade, should I write the first patent on mechanical and nobody will have freedom to operate? Should I write the first one mechanical and the second one, which is electronical, because everybody now is buying electric shade? Sorry. Or should I write 3 generations altogether now, just in the first time to write all the 3 generations? So what is your opinion? What should I do?
How much is the cost of everything?
$60,000 per patent.
Well, it depends on how much money you have.
The market is $6 billion.
Right, but maybe you don't have the initial amount of money, or maybe you don't.
Let's say you have
the initial
a rich
amount.
uncle and you have your money.
Okay.
Let's just pretend you have a rich
Well,
uncle.
if I'm very rich and I want to be the queen of shades, then I should write all 3.
Okay, so this is a good answer, but I'm not sure this is the only answer. Let's look again about the timetables. This is a timetable. Let's try to understand what's happening here. If I'll file today a mechanical patent, okay, it will be published in 1 year, 1.5 year, it will be published. Okay? Can I file another patent, a improvement patent, after 1.5 years about the electronical arrangement? Can I do it? Why you saying yes? Why? What is the reason you say everybody's saying yes by the head? Why? Because you have another degrees of freedom. Okay? Electronic parameters are larger than the number of freedom to operate you have, the degrees of freedom you have. It's okay with up till now? Okay. Why what?
I don't know.
If a code is moved in only one way, it can move it in another way, you have another freedom to operate. If it moves in a mechanical way, now electronical way, this is another parameter. You can file on that patent. Okay? Now, if you have a patent on a mechanical way, you can prevent others using mechanical and electronical. But if you have electronical, you cannot prevent those or doing, let's say, feedback mechanism. So the really correct way to do it is looking in this presentation and understand what is written here. If I file a mechanical patent application, I have 18 months to think what to do. And then after 1.5 years, I can file the electronical patent. And after 1.5 years, I can file the feedback mechanism in a way that in, let's say, 4 years, all the technology belongs to me, and nobody will have freedom to operate. Are you following this? Okay? Now, something about doctors, professors, and students about this graph. Please note that the filing date, this is the real crucial date. You cannot present nothing after the date of filing a patent. So if you have a very nice concept in your head and you want to file an article to the JAX, and the JAX is very, very keen to have your article, don't send the article, but send it only after you file a patent. If you file a patent after the article was published, you will not have a patent. So every time you have an idea, the correct way, think if you should be filed as a patent. If yes, file a patent. If not, ruin it, kill it, and publish it as an article. Now let's talk about another question I've been asking in the break about who owns your patents. Who is the inventor is very easy. Inventor is the guy, a person, who contribute for the definition of the technology, who contribute for the definition of the claims. Inventor is someone who contributes for the definition of the claims. But who is the owner? Who owns the patent? Who gets the money? Now, in your case, your sensitive case, it depends. If you are in your second degree or third degree, MSc or PhD, more likely that you are not owning your patents. According to the Israeli law, as much as the European law and American law, a guy who was hired to invent, who works for employer, and the invention was invented at time it was employee and for the employer, and when the invention is dealing about what he's doing in the laboratory, the inventor is not the owner. The university is the owner. Okay? So if you have an idea, you should go to the owner, to the university. It's called Ramot. The institute, the company calls Ramot. Should
Tech transfer.
the technology transfer organization in Tel Aviv University is called Ramot. You should go to Ramot, tell them that you have an idea, tell them what the idea is. If they like to commercialize it, they will commercialize it. You will be the inventors, but not the owners. If they will not like to commercialize it, they will give up and they will give you your invention. Now, let's say that you've got $100,000 from this invention. So the university will give you a portion of the income, a portion, but most of the income will come to the university. So service patents belong to the employer, not for the employee. So if you're an inventor, very nice to be inventor, but you are not owning nothing. You just contribute for the definitions. Now the last question I was asked is about, you have time? The last question I was asked is about presentations of abstracts in conferences, etc. When you send an article, it's very easy for you to understand I should file a patent just before. But if you're invented to present a poster, which is very common for the second degree, for the MSc students to present a poster, what should you do? The legal advice is not to present a poster, just wait until filing a patent application and just then filing a poster. I cannot tell you how many times I am, as a patent attorney, killed the commercialization of a technology just because the professor or one of the students presents the technology very briefly in a poster. So everything you present, you should consider just beforehand, should it come to be a patent, yes or not. If it should come to a patent, go to the technology transfer organization in your university, tell them all about it. They will file the patent with their own money, not your money. And if not, they will give you the technology back. Okay? Yes, please.
So you you're saying that if you present an idea somewhere, you can't patent it?
Yeah.
Or is it, so it's very direct. Once you presented it anywhere, you can't patent it, or it's just if someone else has heard what you said and does something with it?
It's very, very simple. If you present it, you kill it. Now, there are two ways to run out from that. One, it is in the US. In the US, just in the US, not in Europe, not in Israel, not in China, just in the US, the inventor has 1 year grace. So you can present something and then in 1 year file a patent. But this grace is only for the US. So if you have your grace in the US, you killed the business plan all over the world except the US. And second is about, it depends what you tell to the public. Let's say that I have a machine that cut the grass and make from the grass big bundles of grass, dried grass, okay? So if I show the machine in a conference, this is not presenting a technology, because you just show what the technology can do, not the way it does it, okay? So if you tell somebody, I can do something, this is not discovery. If you tell them the way you're doing what you are doing, this is a discovery. So you can present beforehand, I can do something, this is okay. You can show off, I can do something. But you should not tell the way you do it. Yes, please.
You said about the 1 year grace in the United States, so as an Israeli, can I file a patent in the United States?
Yeah, you can file patent all over the world. Nevertheless, the business plan should be only in the US, because it's not patentable in Israel, in Europe, in China, in Canada, nowhere. Only in the US. Now, US today is only third in the world. So if you do so, you are killing about 2/3 of the value of your technology. So yes, please.
So what is being done with all these inventions that were already published by mistake or something? Nobody can develop them, there's nothing that is done with them?
No, if you publish something before you file a patent, you just cherish the universe and just give him for free all the knowledge you have. You can have no royalty for that, no money for that. They must cite your name as the giver of the information. It's very nice to have your name.
But if you find a cure for, let's say, Alzheimer, and you published it in Nature now.
So you ruin your chance to be rich. But you taught everybody what to do.
So no pharma company will develop it?
No. No.
Because they will not get revenue?
No, never. Yeah. You should be very careful on that. Now, if it was not so easy, this presentation, I'll go to the second presentation that I feel will be much more complicated. But please ask more questions, okay? I can answer them, I think.
If you share the idea under CDA, it's okay?
Yeah, it's not public.
It's not okay.
So what I am doing, very good question. What I am doing for all my emails, it's written just below, confidential. Everything I send to my wife, I send to my children. Everything is confidential. Really, this is the letterhead just below, the footnote. It's confidential. Now, if you say it's confidential, it's confidential. This is not public. So you can disclose for, let's say, 2,000 people something, and it will not be regarded as a public because each mail was confidential. But if a guy outside this group will publish it or use it, you cannot do nothing with this. Okay? So please write confidential, whatever you're doing. Yes, please.
You write it at the end.
Say it again.
Edit.
People will think I'm crazy paranoid.
Okay, about patent structure. This is quite more difficult. I'm sorry for that. Now, patent has two big chapters. One chapter is the description chapter, and the second one is a claim or definition chapter. This is okay? Now, I'll try to explain what is in the description. In the description, there are two main chapters: background and description. Sorry for the same word. Description and background. Now, description is very easy. You just should describe what the patent is. Are you doing what you're doing? It's very easy to understand. Okay, nothing to say. So what is the background of invention? This is very difficult to understand. Very difficult. I try to explain with my face. I know it's ugly, but be concentrated. Now, let's say I want to file a patent about my face. My head. Sorry, my head. So in the first paragraph will be the head himself. So just consider taking my head into Gevis? Cast, thank you so much. Shove your head within the cast for 2 seconds and then take it out. So the cast himself, okay, is not the head. The cast himself is the opposite of the head, okay? The negative of the head is the cast, okay? You shove your face and take it out, so now you have the opposite of your face in the cast. You understand up now? So if I have something very long and disturbing, it will be a recess within the cast, okay? Just the opposite, okay? So background is like a cast. I'll explain why. In background, you should never tell the invention. In background, you should not tell, so I'm here to invent something. You just need to explain in a very correct way the long-felt need. The long-felt need without the solution. So if you take my big nose from the cast, the long-felt need is the recess of the nose. You should not say there is a nose. You should say there is a recess, there is a bore, there is emptiness. Okay? You just call it as an emptiness, not as a nose. So it's very complicated, I'm sorry, but in the background you describe in a positive words, negative ideas, things that are not there. What you just explain the fault, the long-felt needs, not the solutions. Now, in discussions, it's very easy. You explain the head. Now, let's just try to think that on the cast, I pour ink, let's say a purple ink. Now I shave my face and take it out. In the cast, you see a very shallow, one molecular ink layer. This is the definition. This is the claim. The claim is just the border between the long-felt need and the solution. Very difficult to explain, very difficult to write, to edit, and very difficult to read. So let's go to this slide. This is the know-how. You can read it in the literature because it's published before we file the patent. And this is the new material. So this is the description. The gap, the interface between what is known in the art and what is new, this purple single layer explanation, this is the claims. Now, see something else. If the know-how is telling something in a huge vector, people talking about noses, okay? So there is a need in the description to talk not in a brief, to concentrate about one vector, etc. and etc. So invention has patent has three compartments: description, claims. So description, background, and claims. Everybody understand that? Now, if you file a patent on a subject, let's say shades of the windows, this is IPC. IPC stands for International Patent Classification. Every patent has its own classification. So if you file patent on window shades, it's in the IPC of window shades. Here I wrote an IPC for medical device. A61B something is a medical device. It's a registry of numbers and letters. In a hierarchy of 1 is human necessities, 12 is a device for. So device for medical necessities is a medical device, etc. So IPC stands for a classification of the technology. Now, it's not so easy because it's not only 2 chapters, description and claims. The description itself has many, many, many chapters, but for sake of time, I will not explain them. I must say that all the patents all over the world are written in the same way. So if you see this scheme of patent, you can read it all over the world. So there is a title, field of invention. This invention relevance to a field of invention, IPC, specific IPC. There is the background with a long felt need. There is the summary. Summary is just insertion of all the claims of the patent. There is description of the figures. In the end, there are figures, little description, all the disclaimers, terms, concepts, everything is in here. And the second section is the claim. So maybe it's not so easy to read it now, but all the patents in the world are just the same. So if you read one, you read all. About the claim construction, I'll just repeat it again. Claim is the definition. So the way you write a definition in claim is one. This is a definition. This is the way to write definitions in patents. There is no other language. As something, useful for something, comprising ingredients A and B. And when you say something new, something novel, you write just beforehand, wherein. Just like saying Tata box. When you see Tata box, it says, okay, something happens there. When you read the locus of words of claim and you see wherein, you see, okay, from the wherein, it is novel. Just before that, it's old stuff. Okay? Now, let's talk about searches. This is a search about CNS, central nervous system. I make a search. I look for the word central nervous system in the title, in the abstract, in the claims of all the patents in the world. Let's say about 90 million patents. It took me about 3 milliseconds to do it because I'm using a database engine. And the database engine told me there are about 15,000 different patents, family, which says about 137,000 different patents in the area. Lot of patents. You can see that each year people file, let's say, 7,000 patents in CNS. 7,000 patents a year. Okay, it's a lot of patents every day. So let's talk about that. If you want to have searches, you can find free, very convenient, very useful engines like Espacemate. It's the European patent machine searching machine. You write worldwide.espacemate.com and you find this search engine. It's a very easy and convenient engine. For the American, they developed their Google patent, which is also very convenient patent searching device. It's free, you can use it, you can read it, you can capture the PDF of all the patents, you can do whatever you wish there. Now, if you are a professional or you're going to the library, you can go to expensive databases like Patbase. We have in the office several Patbases, and all the presentation of today will come from the Patbase. But if you'll do it also in Espacemate or Google, it's just the same results. Okay? My figure will be much nicer, but the data was the same data. So coming again for this Patbase research, I look for CNS in the claims, and I saw there are hundreds of thousands patents of that. And you can see most of them are patents filed from the beginning of the century up to today. Now, if I read all those 137,000 patents, if I read it, I'll see the keywords which are common on those patents. Yeah? So this is the keywords mapping of the CNS patents. This is the normal keywords. Now, if you read amino acid, there is a great chance you'll see halogen atom just near amino acid. If you look for pharmaceutical acceptable salts, you'll find other wording. So you can find patent according to the IPC, International Patent Classification, or according to the keywords. I will try to urge you to look for patents only with their IPC, and I'll show you why later on. So if you look who files those patents, you'll see that a very nice graph shows how many applications were filed and how many patents were granted. I just tell you that a patent, it will take you about 5 years in the day you file it, up to you get it, okay, 5 years. So you'll see that Pfizer is the biggest company in the world for filing patents where the word CNS is there. Now, there are two kinds of Pfizer just because there are two companies Pfizer. Pfizer Incorporation and Pfizer out of Pfizer, but the same company. So they filed, let's say, 2,000 patent applications, Pfizer. Now, the second company is Wyeth. Now, Wyeth is a very old company. Wyeth's brother was living in the in the end of the 19th century, and they were bought by Pfizer and by Nestle. The CNS division by Pfizer, and the nutrition was consolidated into Nestle. So the second company with Wyeth is actually belong to Pfizer. Now the third company owning patents in CNS is Genentech. So you see there are two kinds of companies. One will be the drug company, Pfizer, and other will be the biological company, the bio companies, like Genentech. And you see that really the most of the patents belong to the pharma company, Pfizer. So in a very short search, you can know immediately who is your possible competitors or who is your possible collaborators. You know that if you have patent on CNS, go to Pfizer or run from Pfizer, just the same. Okay? Second to best, go to Genentech. Now, as we talk, we had 15,000 different families. I asked my computer which patent was mostly cited. All patents are cited by other patents. So I look who was the most cited patent. And this patent is owned by Lipokin. Okay, I will talk a few words about this patent. So this is the most cited patent in CNS in the world, ever. You'll see that every year, about 800 patents are citing their patent. About two times a day, people file patents, and they are citing the patent of Lipokin. This is a very well-cited patent. Now, you'll see that Lipokin usually cite their own patent, but all the industry cite this patent. So this is the way to look about that patent. There is a title, there are the inventor, there is the owner, assignee, which is Lipokin, there is the abstract, etc. This patent was filed, let's say, in 2002, and was granted in 2008, 6 years. It's dealing with CNS. You'll see here, I'll just mark a place where you see it's related to CNS. Now, let's talk about soups. Let's talk about the military soups. I don't know if you remember your soup in the military, but usually the chef them call the soup as something as two ingredients, primary composition and secondary composition. I'll try to explain. When the chef in the army is doing his soup, he's making a soup. It's just, this is a tomato soup. So it's not water, it's not hot water. It's something, it's emulsion of something or combination of few ingredients together. This is the primary content soup. Now within the soup, you have your secondary content, okay, can be anything. Now they can make those two components differently and mix it up later on, you can do it just at front. This is Israeli army soup, okay? Just the same is Lipokin patent, just the same. It says there is active agent and it divided into suspended particles, and there is multi-particle and single particle, and the single multi-particle are divided into two families, etc., and so on and so forth. So they invented the Israeli hot, ugly, untasty soup, okay, just the same. So let's read the claim. Now you know how to read claims. it's a drug, useful for being drug. It's comprising A and B, and the invention is wherein. Now here they've got two whereins, two inventions. They've got the first invention and the second invention. Now in a Boolean way, when you have two inventions together, your pattern is narrower. So they have something new and something new. Let's say a chair with the wheels, and when the column of the chair can rotate. Okay? It's a very narrow patent. But this is their patent. This is, we'll call it independent claims. Now, this is a dependent claim. Why dependent claim? It says you take the composition just above and you take it to be more narrow. You're narrowing the pattern. So this is the drug of claim 1. We're in something new. This first fraction, the soup, comprises phenylfibrat in a concentration. Okay? So this is a kind of pattern of CNS. It's very easy to read if you understand that before we're in, it's known in the art, and after we're in, this is a new particle, and you try to simplify as much as you can the language to things you understand them. So the money path comes from a team to the IP patents, from then the technology, from then to the market, and then to the regulation. I will try to have some words now about the technology and the market, and what search, IP search, patent search can help you in finding technology and finding the markets. Okay? So there are a lot of reasons why to perform searches. I elaborate here just a few reasons why to do searches. I forgot some of them. So the first reason is to identify and to navigate between trends. There are a lot of trends that the science has its own trend which change once a year. And if you want to identify what are the current trend, or what was the past trend, or what will be the future trend, search will help you. I'll try to show you how you do it. If you want to have business development tools, who invite, which company, who are the persons which I should collaborate with or should be afraid from, when they are filing the patent and where they are filing the patent. Should we have patents only in the US? Should we have patents only in China? Should we have them both? This will be answered by a search. Now, if you want to have a collaboration with a company, or if you want to escape from collaboration, because you know that every collaborator is a competitor. If you sign with him a competition, if you sign for him for collaboration, is your collaborator. But if you're not signing a collaboration with somebody, is your competitors. So who are the competitors? Who are the strategic partners? If you want to assess the market, in what use we can use our products, for which use? You can do it in a search. Or if you want to define a product for technology, which product the market is looking for, you can do it in search. And of course, if you want to have a portfolio of patents, portfolio of mechanical window shades, electrical window shades, etc., you should do it by search. For business playing, and if you want to tailor your product to face the regulation as optimum as you can, this is by search. So I give examples. I'll take one technology. This is IT, information technology. Okay? I look at the information technology all over the world when it is in the abstract, in the claim, in the title. There are, let's say, 10,000 families which provides us with more than 60,000 patents. Most of them are patents and most of them are granted. And people file those patents in IT all over the world. Now, I will not look for information technology. I look for the IPC of information technology, the classification of IT, and I get this kind of presentation. Here, the number of application, and here the number of application patent. This is granted patents. You can see that the biggest IPC, most of the filing and most of the granting is in the code G06F, which means in physics, computing, and data processing. So if you look at G06F, it's like looking at data information, like IT. I'm not sure that the silent is good, so I give an example. If I want to look about technology about television, so I look for television. Television, you can write it in Hebrew, in English, just send television, televisia. In French, télévision. But if you want technology of television coming from Germany, you will never say television in Germany. You say Fernsehen. Fernsehen is television in Germany. And I don't know how to say it in Chinese or Japanese. So you should not look for television. You should look for the IPC of television, where you are in context of television, but you're not using the keywords television. It's okay? Understand me? So better for us for looking the IPC G06F, because otherwise not saying into IT. Now, if you're looking at the time of this filing, you'll see that at a given time, let's say in 2007 or 2006, people file more than 11,000 patent applications per year. It's more than 400 patents a day. It's more than 10 patents an hour. It's 20 patents an hour in IT. Okay? So this is the map of IT. You can see that we'll never look beyond 18 months of our age, because patents are confidential for 18 months. So if there is a huge reduction of publication just because patents are not published in the last 1.5 years. Okay? So let's discard this portion, and what can we say? We can say this is a post-peak technology. This is a post-peak technology because the peak was in, let's say, 2008, 2006, and from them the technology reduces in a great manner. Yes, please.
Let's say you file a patent tomorrow.
Yeah.
So it might be that someone filed a patent, the same thing or similar thing.
Day before?
But you wouldn't know it.
Okay, it's a very good question. Thank you. So if two people file a patent, one will file one day before the other. So the second patent is patentable in regard to the first one, because when he filed the patent, it was not published. So the second patent is patentable. It is novel and having an inventive step. Nevertheless, the second patent will not have freedom to operate, because the rights of the first patent is to kill the second technology.
If for some reason the first one will fail, or I don't know, some other reason.
Yeah, when you have a search about patents, you are not reading. You're not reading patents were filed 1.5 years before, just more than that.
But when will they tell you, listen, someone filed it, and then so it will be like it will take you 1.5 years. You would sit in your house and think, okay, I filed it.
It's a very good question. Thank you for the question. Thank you for the question. Very good question. There are 3 stages of patent: Paris Treaty, PCT, Patent Cooperation Treaty, and National Phase. In the PCT, there is a search. And the search is, we are beginning the search exactly 18 months after the filing. So after 18 months, you will know who files patents before you. Now, if the PCT search will show that somebody filed patent a day before you, your patent will still exist, but you will not have freedom to operate. Okay?
So you're spending money?
You're spending your money. Everybody spends their money for 1.5 years, yeah. For nothing.
It could be for nothing.
Yeah, I have two stories to tell. One story I was winning, one story I was losing. I have only two stories, and the 2 stories, one 50%. Yeah, 5 minutes. So I'll tell you the story because it's related, but I will not continue from that. We'll do it in the 3rd lesson. In the first story, a professor from the Hebrew University invited a 3-dimensional printer who prints foam, which is he print food ingredients on other foods. Let's say if you have a coffee, you can print on foam, or let's say eatable foam, on this coffee and see a logo or a joke or something. So we invite this patent. I understand this patent is very important. So in the same day he told me about the patent, in the same day I went to the office patent office and I filed this patent. And this professor got a lot of money from the industry about this patent application. And after 18 months and a few days, we discovered that a day before, another patent was filed and everything was thrown to the trash. He had nothing. Okay? Another story is about hummus. When I was young, I was located in Jerusalem, and one of the hummus kings of Jerusalem, I will not give his name, but one of the really holy king of the hummus of Jerusalem came to me and gave me to taste wonderful hummus, which is hummusless hummus, hummus without hummus. And it was wonderful hummus, and as a Jerusalem guy, I cannot breathe that the guy is just speaking to me. I taste the hummus, wonderful hummus, and we filed the patent the same day, because in hummus in Jerusalem, you're not playing with that, you're filing the same day. You should know the guy is very frightening. So I filed the patent the same day. He just told me the date, I filed the patent the same date. Now, many years later, he came to me, asked me how to commercialize the hummus. I told him, I don't know, you should sell it to a hummus company, let's say Strauss, I don't know, just giving a name. And he asked me to come with him. We take the train from Jerusalem up to north of Israel, and we went to a company, and we told them about our hummus without hummus, and we gave them a taste. It says it's a delicious hummus, but they cannot buy it because they have a patent on that. And we're sitting with a rich guy of the other company, with his food technologist guys, and he says, we filed a patent. We cannot buy your patent, even though your taste is much better than us. So I asked him, okay, just give me your number. You filed in Israel, okay? So give me your number, and I'll tell you what is my number. And in between, we understand that we filed the patent a day before they filed the patents. Now, the rich guy from the second company, he looks for that his food technology, we didn't file his patent, wished to kill him, but we had the priority. So we sold them our hummus, and our Jerusalem rich guy became to be much richer. And I think you know this hummus without hummus product. It sells very good in the States. It's not selling so good in Israel. Sells very good in the States, and should be very sensitive for the filing date. So we didn't finish the first one. We finished too early, and this is finished too low. The third lesson, 2 weeks from now, will be very simple: how to do money from patents. This is how to do money from patents. We try to learn some things to do, things not to do, and we'll begin with that. Thank you all.